Okay, good morning.
Good morning.
Good morning.
Welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eisnagel. We have on the panel today Judge Harris and Judge Lambert. And this session we are hearing case number 2298, State of Florida versus George Brown. And so the appellants, whenever you're ready, you can proceed.
Thank you, Your Honor. May it please the court, my name is Pam Kohler, I represent the state of Florida. I'd like to reserve 5 minutes for rebuttal. The state is appealing an order granting a motion for post-conviction relief based on newly discovered evidence. At trial, the defendant was charged and convicted of second-degree murder. The incident involved a bunch of high school kids going to a club. Apparently the club, they had to pay $20 to get in the club, and soon after they arrived, including the defendant, they were told to leave.
Counsel, it's entirely your decision how you want to use your time, but I think the panel is pretty
familiar
well
with the
versed
facts.
on the facts. If you want to highlight some key facts, but you don't need to go through the whole thing.
Sure. Number one, obviously, we're challenging the trial court's findings regarding and the competent substantial evidence supports her findings. She found James Viville, the recanting witness, credible as the initial regressor and that he carried and displayed a firearm. Just because he is currently serving 2 life sentences and he had a reason to lie before to law enforcement and to the prosecutor. However,
that was kind of an odd concept that I'm serving 2 life sentences, therefore that tends to make somebody more credible. Historically, I think that's the opposite view of somebody's in prison and they're
yes.
But that being said, there was another reason that the judge found him credible. So,
and that he had a motive to be untruthful to law enforcement and the prosecutor at the time. However, I would submit that he essentially recanted from his recantation when he got to the evidentiary hearing. I mean, he admitted that he had shown the gun to the defendant by the club and that he was the first one to mush the defendant. He didn't punch him, he mushed him. And then he said that when they went to the ditch, they all ended up in the ditch area. He had pulled his gun and he said he pointed it down at the ground because he's trying to gain control of the melee and that he never chased the defendant. In his affidavit, he specifically said that night, your affiant did instigate the fight and has a firearm and had pointed at Mr. Brown intending to shoot him and that he had chased him to the car, which is why the defendant felt the need to pull his gun. Of course, the huge problem with this version of events is that the defendant has never testified to that. Never. This is not a case where the defendant testified at trial. Hey, some dude showed a gun to me. So I pointed a gun at me. So I took off running to my car and I pulled my gun and he chased me. And so I pulled my gun and I started shooting at him. The defendant has never, ever made that claim. He said the only place he saw a gun was in the ditch. Some guard pulled up a gun in his shirt, showed a gun on his hip, but that he was the only one who actually pulled a gun.
And that guard seems to be somebody named Chris, because doesn't Mr. Viville say that at the 3850 that a guy named Chris always had a gun?
Always had a gun
on his hip, and so that would kind of link it together. But apparently Mr. Brown did see some guard with a gun.
Right.
That's his trial testimony. Now, when you say recantation, is he really recanting anything, Mr. Viville? He said he was the one who pushed first, and he didn't say at trial, I never had a gun. He was never really asked that if he had a gun at the trial. So this is kind of newly discovered evidence that he's now expounding upon what he said at the trial. But it is new. I mean, about having a gun is new. Now, whether it's significant or not, I think is probably one of your issues here.
Right. Well, and the fact that in his affidavit, he specifically said he had a firearm. He pointed at Mr. Brown and intending to shoot him. That's what he said on page 124 of the record. That's in his affidavit. And then he goes to trial and he's like, oh no, I never pointed a gun at the defendant. Oh no, I just put the gun down and pointed at the ground because I was trying to, break up the crowd.
You said at trial, you mean at the evidentiary hearing?
Correct. I'm sorry. Yes. Yeah. At the evidentiary hearing, he said, I never pointed the gun at him. And then he reiterated his testimony at trial that I wasn't chasing the defendant. I was walking with my brother accompany my brother, looking for my brother, something like that.
I mean, counsel, as far as the credibility goes, I mean, how does this court, I mean, sure, witnesses make inconsistent statements pretty routinely, right? Are we supposed to write an opinion that says a trial judge abuses their discretion if they believe a witness who has conflicting statements?
Well, that's part that goes to credibility. But
I'm just trying to find out, what you propose that we write.
well, that there is not competent substantial evidence supporting the credibility determinations, and that because of that, there was no.
Why not? I mean, he got on the stand. He said, yeah, I had a gun. His statement is different than his affidavit, but why is the trial judge is the one seeing the person testify? How does an appellate court write an opinion saying, hey, look, if there's conflicting statements by this witness, then game over, you can't believe them?
Well, because I would say, she makes a lot of findings as far as that everything was all consistent. I mean, everything was consistent. I mean, it's almost as if she didn't actually read the trial transcript. And again, the bottom line is James Beville's testimony is not only inconsistent with everything else, it's inconsistent with the defendant's own trial testimony. It's different if this.
How? I mean, I'm not sure I'm seeing that. How is it inconsistent with the defendant's trial testimony? Because
the defendant never testified under oath when he was asked that nobody else drew a weapon. Nobody. He was the only one who drew a weapon. The defendant, James Beville, is now saying, I drew a weapon, and I know the defendant saw me because he took off, he left the area. Now, the defendant never said, I took off running because someone pulled a gun. He said, I saw someone had a gun, and I wanted to get away from that because they're being beaten up on. And he took off running. They all took off at a quick pace towards the car. He also,
I'm not following, counsel. I'm sorry. What exactly about the testimony, the evidence you're hearing is inconsistent with the trial testimony?
The defendant has never testified that anybody ever drew a gun, pointed a gun at him, that he was afraid of when he was asked.
But him not testifying, hey, somebody drew a gun. First of all, at the evidence you're hearing, who said that they drew a gun?
That would be James Beville.
He didn't say he drew a gun.
At the evidence you're hearing, you said he drew a gun?
Yes, he drew a gun. He pointed it at the ground because he wanted to break up the fight.
I see what you
mean. He never pointed it at the defendant.
I got you. Okay.
And then he had claimed he took off after him in his affidavit, but then he said, no, I didn't.
When you said drew a gun, I thought you meant, pointing it, drawing it and pointing it.
No.
That's not what you meant?
No, he testified at the hearing, he drew the gun. He did not testify consistently with his affidavit that he pointed the gun.
Well, Mr. Brown at trial talked about somebody putting a hand on his hip where there was a gun. So
there was one witness who saw somebody pull up, and then he thought it was a taser when he told the cops. But then by the time of trial, he said, well, it could have been a gun. But he admitted he had told the cops it was a taser or something like that.
Well, I haven't. Mr. Brown said one of the security guards had a gun, grabbed his.
Oh, Mr. Brown. Yes. Mr. Brown did. I'm sorry.
So there's a mob, there's a melee or whatever term is going on, and he sees some of these security guards with a gun, has a hand on there. He's out of the ditch and he's going towards his car to get out of there. And the mob, well, I guess that's the term we're using. The mob all follows him in that direction. And so he turns and gets a gun and he fires because he wants them to stop doing that because he apparently got beat up pretty good while he was in the ditch. I mean, is that?
Well, he says he was beaten up, but they introduced pictures of the defendant. And according to the state attorney's closing argument, he didn't have a cracked lip, a bruised eye. I mean, he was dirty, which he said he got dirty because when he was arrested by law enforcement, he also claimed that to the cops that night that someone was trying to pull him out of the car. And then he admitted, oh, no, nobody's trying to pull me out of the car. That he said, he admitted that he testified no other gun was drawn before he drew his gun. He was afraid they were trying to, trying to beat me up real bad. That was his testimony. Never that he saw a gun, and that's why he ran, to the car, was to get a gun and start shooting.
He did say he saw a gun, I thought.
He said he saw a gun, but he never said it was drawn.
You just said that hold on, counsel. You just said that he never said that he saw a gun. He did say that.
And that is why he took off running and got the gun. He never said, because I saw that gun in the ditch, I ran to my car to get a gun.
That's fine. I think you're right. I don't remember him ever saying, and that's the reason why I went and got my gun. However, upon reading the testimony, it certainly seems like one could make the case that there were sort of a culmination of problems here, all right, of a threat where it's sort of the mob, plus there's a gun present in the mob. I mean, why is it not scarier and relevant here, a mob versus a mob with a firearm? Why does that not matter?
Well, because there was also testimony, and again, I get that, but he never, when he was given the opportunity to explain why he reached for the gun and started shooting, it was never that I was afraid I was going to get shot. It was never that I saw a gun and I was in fear for my life. It was never that, the only reason I started shooting was because I thought I wanted to shoot first or something to that extent.
Does that have to be the only reason? I mean,
but he doesn't even say it. I mean, he doesn't even say when they ask him, what he says is they were trying to beat me up real bad. And he was mostly afraid of Marcus Nieto, not the two twins, as they called them. He was mostly afraid of Marcus Nieto. So it wasn't even the one who had the gun.
Wasn't the testimony referencing the mob? He didn't say I was afraid of this one person, right? He was afraid of the mob, right? I mean, am I misreading?
He talked about, he was mostly afraid of Marcus Nieto, but he did talk about the fact that there was all these people that were there. But the thing was, he was also overheard saying that I've got something for you all, fuck this. And he started shooting. So,
that's a great fact for the state to argue to the jury, right?
Right. But it's also consistent with the fact
how does that sort of negate the trial judge's findings at the evidentiary hearing?
Well, she found that this was at most an impulsive overreaction. And I would submit that the fact that he had time to, get away from the crowd and get to the gun, and that basically his reaction is that he's angry, so he wants to shoot at the crowd. Or even if he was attempting to shoot Marcus Nieto, we don't know exactly what he was trying to do. He claims he was just shooting over his head, although, and again, another thing that the trial court found that I wanted to get to is that she said that his defense at trial was consistent with the physical evidence, and it was not. I mean, he said he just shot up, he closed his eyes and shot up into the air to scare everybody. Now you've got two victims who got shot, one got multiple shots, and he got shot in the lower abdomen below the belt line, from right to back to left, slightly downward. And then he also had one in his arm and through his nipple. The other one was shot in the leg below his right knee. So the idea you're just shooting up into the crowd. I mean, he's shooting, he's mad, and he's taller.
He's scared.
He's 6 foot.
He's scared too.
He said he was very scared. Absolutely.
Well,
he did.
That doesn't seem to be an unreasonable position to take. That, if I understand, the two Beville brothers are about twice the guy's size of weight, and Mr. Nieto is big, and their whole mob is coming in that direction, using the term we're using today. So he pulls out this gun because he wants them to leave him alone. I mean, I don't know if it's impulsive per se, but I mean, it's not like there's a 10-minute gap between I get to my car and I'm waiting for the mob to show up and I shoot. I don't get that happening.
But I'm also saying that she makes the finding that the physical evidence was consistent with the defendant's testimony trial, and it was not, as far as that was concerned.
Well, now you have, let me ask you, there's three other witnesses who testified at the 3850 hearing, two without objection, and the judge finds them to be credible. Now, that would certainly be admissible evidence at a retrial. You've not raised that here, that was error to admit that evidence. And those three independent witnesses certainly seem to help Mr. Brown's case at a retrial and both at the 3850 to suggest that, because if you read Mr. Beville's trial testimony, and then you compare it to what he's saying at 3850 with these other people, he's much more engaged and aggressive towards Mr. Brown than what his trial testimony suggested. So, if we look at the newly discovered evidence, which is Mr. Vaville's testimony, that would probably produce an acquittal on retrial. That seems to be the issue we have here, because it's not really a question that this is new evidence. But apparently we have to factor in what these other witnesses have said, or you certainly have not argued against it here.
Well, I mean, again, she finds them all to be consistent, and they're not really. I mean, one says
credible. I mean, it's like, I think what Judge Eisenhower, the fact that there's some differentiation. I mean, it's not like, I think the analogy was, well, I'm looking at the stop sign, is it red or green? This is an ongoing frantic event, and these people are all reciting things that they are seeing, and it's not horrifically inconsistent. There might be some inconsistencies, but it all seems to suggest that Mr. Vaville and his brother and the security guards are really engaged aggressively against Mr. Brown, and he's trying to get out of there, and now he's defending himself. And this evidence certainly gives a stronger position, I would think, at retrial if it all comes forward like this, as I see it, which is I'm one of the ones you have to convince otherwise.
Yeah, no, I mean, I would submit that it does not, that because of the inconsistencies, you go to trial, it's just another version of events. It was clear that there was a fight between the guards and the high school students.
Well, but one of the most engaged, aggressive people now is going to say to the jury, and I have a gun and Mr. Brown saw it twice. You certainly can cross-examine this. If Mr. Brown testifies, says, well, you didn't say that at trial, you think that'd be something that would stick out in your mind. I agree with
Absolutely.
all that, but as Judge Eisenhower points out, the judge, for whatever reason, oddly in some fashion, but in other fashions not, found that this is all credible, that we have to kind of accept that. I get what you're saying. There's not substantial competent evidence. If I guess there was evidence that, Mr. Vaville was actually in Alaska at the time and he's making this all up, and the judge still found him to be credible, then we'd probably say, no, we're not going to buy that. But we're not at that level here. I mean,
I can see I only have 3 minutes left, but I would disagree, and I will come back later and explain.
Okay.
Thank you, counsel. Okay, and counsel for the appellee, you can proceed whenever you're ready.
Good morning. May it please the court, counsel for the state, Paula Kaufman. I have the privilege of representing Mr. George Brown this morning. Firing with eyes closed in the direction of an angry, charging mob is at most manslaughter, not second degree.
But you've lost. I mean, that was issues for direct appeal. To me, I mean, that certainly can be argued in direct appeal. And if it wasn't persuasive. And I don't know that the evidence helps you more to suggest it's manslaughter as opposed to second degree murder now, because it sounds like before it was his version versus the other people. Now he's got other people saying, look, he has a real reason to be mad at everybody because they're wailing on him. And now he went to get a gun. He's got ill will and hatred and evil. He might not have known these people, but he got to know them quickly. And now he shoots. I would suggest, at least as to me, that's not your best argument here, that, oh, by the way, this is a manslaughter. We could have, I guess, as we did in Sandhouse, could have said it's only manslaughter. But, you make your argument as you choose.
And in fact, Judge, the state did fall back on the argument that the evidence was sufficient to sustain a conviction for manslaughter.
Well, sure. They're not saying if you don't convict him of second degree murder, let him go. I mean, that's a category 1 lesser included. And we certainly talked about that in Montgomery and all that stuff.
It's our position that this is a case of self-defense. I am strictly pointing out that the reason Judge Harris granted relief here, and the law that applies to the facts as found by Judge Harris, the law that applies to the facts as found by Judge Harris was not even addressed in the state.
You're not talking about this judge. You're talking about Judge Harris below.
Yes.
Right.
Well, because
Yes.
Judge Harris actually wrote the 3850 reversal here. So let's all be clear.
Okay.
That was the previous case.
Right. On these two grounds. That was I'm sorry. My bad.
So
I'm sorry.
it is the law in Florida that what we believe a jury would believe in a retrial is at most manslaughter, if not self-defense.
I mean, counsel, you have to, I think part of what the state is saying is, look, he didn't say at trial, it's not like he got up at trial and said, look, I was being chased by a guy with a gun. I was scared. I thought he was going to shoot me. So I pulled out my gun and I tried to shoot him first. I mean, he didn't say anything remotely like that, right? So, I mean, I think what the state is saying, look, if we just look at at your client's testimony at trial, the state's saying, look, maybe the fact that this guy had a gun isn't really all that relevant to your client's testimony.
I don't believe the newly discovered evidence is inconsistent with the defense.
No. I didn't say inconsistent. I said relevant. How is it relevant, right? It has to be relevant. Don't you think it has to be relevant? I
mean, Judge Eisenhower was basically saying, if your guy at trial had said, oh, by the way, one of those guards right there had a gun and he was coming at me. Him and his brother were coming at me. And Mr. Vivol said, I didn't have a gun. I didn't have a gun. And now 15 years later, he's saying he had a gun. Your case is a lot easier. And you would think that your defendant at trial would say, that big guy right there showed me a gun twice and I was skedaddling out of here. And so I got my gun to get him to stop so we can get out of there. That would be a certainly easier case for you to say, Judge Harris, not that guy up there in the corner, but Judge Harris below said, hey, if the jury had heard that, absolutely. But
I agree, Judge.
That's not what we're hearing, so that becomes problematic.
And as we pointed out in the brief, the trial testimony of the defendant is worth reading, as is the entire trial transcript.
I read his transcript testimony.
Defense counsel appeared to be conducting discovery depositions during the trial.
Well, but that's not the issue right now. I mean, I know you kind of took a shot at her at the end, and that's not, don't do that. That's not what we're arguing here. You didn't say that.
With all due respect, I think it's fair to consider what the retrial would look like. It would be different. There would be new witnesses and a much better.
But counsel, I mean, yes, but what I'm not sure that your client has the right to change his story, right? I don't know. Does your client have the right to say, oh, well, now I think it's better for me to focus on the fact there was a gun. And so I'm going to now change my story, change the facts, and give a new sort of version of what happened, because now I think that based on this new witness, that's helpful to me. Your client's not entitled to do that, right? Your client just has to tell the truth if he's going to testify.
He has the right to answer questions that were never asked the first time, and he has the right to be more clear in responding to the questions that were asked. I'm thinking in particular of a question being asked about, did you see guns being drawn? And his answer was, not during the fight. That doesn't mean he didn't see guns being drawn at other times. The decisional authorities affording deference to the trial judge's superior vantage point in this case in evaluating bearing, demeanor, and credibility of witnesses are typically cited by the state to shield the denial of post-conviction relief from a reversal. We are asking this court to apply those decisions uniformly, regardless of which side is relying on them.
Of course, counsel. I mean, of course,
we understand all that. I mean,
yeah, I mean that's elementary, counsel. I mean, of course, that's what we will do and what we do. But I think the question here is not, do we second guess the trial court's credibility findings when they're supported by substantial competent evidence? I think the question here is, to me anyway, is whether this new testimony about the gun is relevant to your client's defense, the defense your client presented at trial, and the story your client told at trial when he testified. And therefore, would there be a likely, is there prejudice? Would there likely be a different result? And so that's the only question. I mean, obviously, I'm not saying it's not relevant. I'm just asking you to sort of explain that, because it's not a slam dunk for you. It's not like he didn't get up there and say, yeah, this guy was coming at me with a gun. And that isn't at all what he said. Although I think he had an opportunity. He wasn't directly asked specifically, did so-and-so come at you with a gun? Did so-and-so come at you with a gun? But he certainly was given an opportunity to say that, and he didn't. which is why I'm asking you, how is the gun relevant? How? Based upon your client's trial testimony.
It is relevant because in a retrial, Mr. Vivel would be subject to impeachment by prior inconsistent statement. In fact, of all the witnesses testifying at the evidentiary hearing, he's the only one who would be subject to impeachment by prior inconsistent statement.
Let me ask this. I mean, we all agree, like Judge Eisner just said, we defer to the credibility determinations, even whether that makes sense as to how the judge got there, All right, but it's still the second prong under Jones is that the newly discovered evidence must be such that it would probably produce an acquittal on retrial. Now, this post-conviction judge is looking at a transcript, just like we're looking at the transcript of the trial. So basically, as I see it, we have to take the credibility findings and then determine de novo, do we agree with the legal conclusion that the post-conviction judge, Judge Jennifer Harris, made, that would probably produce an acquittal on retrial? Do you agree with that?
I do, and I believe what the state is saying is that the court's conclusion that there's a reasonable probability that the outcome would be different is because they believe Judge Harris below, the finder of fact at the evidentiary hearing, believed the wrong evidence.
Well, I actually think the state's argument is better if they would have said, okay, credibility, that's what they decided is credible. Let's accept it as credible. If you then take that credible evidence and then look de novo here, that is not something that would probably produce an acquittal on retrial for the reasons Judge Eisner explained. Your guy never said, oh, by the way, that big guy had a gun and he was chasing me. And so I went to my car to get a gun to defend myself and shoot back to stop him from shooting at me or hurting me. That never came out. Now, and that's where your case is better if that's what had been happened. But yeah, your guy can't come up and change his mind and say, oh, I now say he did have that. He did have the gun. Well, let me jump ahead for 1 second before we get to that. The three witnesses that that also testified, the other people who were there, I mean, they were the topic of ground 4 of the last post-conviction motion that was summarily denied and was PCA'd here. I mean, if I'm under reading Jones that basically says, okay, the post-conviction judge has to take the newly discovered evidence, weigh that against the evidence presented at trial, and then decide whether it would be likely there, reasonable probability there'd be an acquittal or a lesser sentence on retrial. How is it that people who are not newly discovered people, no, that's not even raised in the motion that, oh, these three guys are newly discovered, Mr. I can't remember their name. One of them's Williams and Roberson, and I can't remember the first guy's name that testified. How is that pertinent here to our analysis, other than that perhaps with some later Supreme Court case that broadly says that you've got to consider all admissible evidence that could be introduced at a new trial? To me, that means if I have a sliver of newly discovered evidence, then I could call 43 other witnesses who I didn't call at trial and say, well, if they only heard that, it'd be a different thing. That makes zero sense to me. Now, the fact that I may disagree with the Supreme Court, but how is that? Doesn't Jones say you have to look at the newly discovered evidence and weigh it against what was admitted at trial? Doesn't Jones, the Supreme Court 1998 case, say that?
It does.
And none of these three witnesses the other three witnesses besides Mr. Vaville testified at trial, and that nobody suggested they were newly discovered. In fact, that was part of the earlier motion saying my lawyer was ineffective because they didn't call these people. And if only would have called these people, we'd have had a different result. And that didn't carry much weight either below or here back in 2016 and 15, right? In fact, weren't you the lawyer in that case?
No, sir.
You weren't, all right. Okay, my bad. So how is that? How do these people?
We're relying on the Florida Supreme Court decision that I believe you're on.
None of which were cited by anybody in the brief. Now, to your defense, that wasn't raised by the state in the initial brief. So that's what's the most troubling thing to me, because that evidence actually ends up helping you more than Mr. Vaville. If this was just Mr. Vaville's testimony oh, by the way, I did have a gun, even though nobody, Mr. Brown didn't see it, I would have a much more, it'd be even more problematic here for me with your case, frankly. But
Did I
go
answer
ahead.
Your Honor's question?
Nah, I guess I'm just ranting in the sense that it's not been raised directly. So, but I'm just puzzled because that was what stood out to me. This is what they're not even alleged in the motion that they're newly discovered witnesses, and all of a sudden they're testifying away, and there's page after page in the order of the judge talking about it.
Even if the state had raised that argument, we all have to follow the Florida Supreme Court plain meaning of their decision.
Well, that's it might be more dicta in some of the later cases. We were having that private discussion amongst the judges. But that being said, there certainly is verbiage in later cases that I've become aware of that somehow, even though it's not newly discovered, it can be presented at a newly discovered evidentiary hearing, and it can be considered by the post-conviction judge. But
Counsel, along these lines, I mean, it seems like that most of the testimony offered by these additional witnesses was sort of directly supplemental to the newly discovered evidence. Would you agree with that? I mean, it was largely focused on who was the aggressor, who had a gun, things of that nature, right? I mean, there was some straying, but a lot of it was focused on sort of supplementing the newly discovered testimony.
I would agree. I would.
Well, counsel, I mean, I think that, the question I asked to appellant's counsel was, and I think probably this is your best answer to my question that I've been trying to get you to answer about the relevance, right? Is that, look, isn't a mob a lot scarier and a lot more significant, if they have a firearm versus just their fists? Isn't that your best answer? At least that's the best answer I can think of. Can you think of a better one?
Most of the facts of this case are beyond dispute. And you've already indicated that you're well versed in the facts from the original trial and the evidentiary hearing. Many of the things that we asserted in the post-conviction motion actually corroborate testimony that was presented at the hearing. The state is asserting that there are internal and external inconsistencies, but many of these facts are beyond dispute.
Let me ask you this. If the newly discovered testimony was that, hey, look, I had a gun, but I didn't follow the defendant to the car, I went back inside. You don't have a case here, right? I mean, how that wouldn't be relevant to why your client pulled out a gun and pulled the trigger, right?
I don't think it's necessary that Mr. Brown saw Mr. Weivel's gun. There were guns out there. One gun.
Well, if he didn't see Mr. Weivel's gun, how is this newly discovered evidence relevant?
Well, Mr. Weivel is one of several security guards.
I understand, but if Mr. Weivel had a gun, but nobody knew it, how was that relevant?
People knew it. And Mr. Weivel explains that he showed it to
you just said it doesn't matter if Mr. Brown knew that Weivel had a gun.
Well,
that's not what you meant?
We don't know that he saw it when Weivel is 10 to 15 feet from the end.
Right, let me ask it differently. If Weivel had a gun, but everyone agreed, that Mr. Brown didn't see it, didn't know he had it, you lose, right?
You can admit the obvious.
I don't know that we do in a
you lose here.
in a self-defense case where he has been beaten, he's being chased by
counsel. The newly discovered evidence here is the fact that Weivel had a gun. If Mr. Brown had no idea that Weivel had a gun, how does that change the result of the trial? Explain that to us.
Because a properly presented self-defense defense could include the fact that Mr. Brown is afraid for his life because he's being chased by a mob of 30 people.
But that has nothing to do with the gun.
Right.
I'm
That
sorry.
was what was discussed at the trial. I mean,
That has nothing to do with the gun, counsel.
you don't get to, yeah, you just don't get to have a do-over because you don't like. I mean, there has to be a hook to get a do-over, and apparently it's I'm now the aggressor and I have a gun. If nobody knows he has a gun, if he never shows that he has a gun, you don't get to just come back and say, well, I did have a gun, nobody saw it, therefore I get to have a do-over. That's utterly illogical.
But
That's
Your
not
Honor,
gonna-
Mr. Vival did not admit in the trial to doing anything other than pushing Mr. Brown. He didn't admit to having the gun, showing the gun.
Counsel,
His
look,
fight-
We're trying to give you reasons to win, and you're fighting
Counsel.
to show us why you should lose.
Counsel.
I apologize.
counsel, we are throwing you softballs here.
And you're just hanging on to the loser.
Let me ask it again. If Mr. Vival now says he had a gun, but everyone admits, including your client, that no one knew he had it. No one knew it. Mr. Vival was the only one that knew he had a gun. How does that change the result of the trial?
Everyone admits that they individually did not know he had the gun, or he, Mr. Brown.
No one knew,
Nobody
including Mr.
knows.
Brown knew.
Nobody who
no
ever
one
was
knew
there.
except for Vival. Vival was the only one that knew, and everybody admits it. Now he says, but I did have a gun. How does that change the result of the trial?
That would not change the result of the evidence.
Amen.
The evidentiary hearing. Is
There
that
we go.
what I was supposed to give?
Well, I mean, basically what Vival is saying now is I had a gun and Mr. Brown saw it. And so Mr. Brown skedaddled and I'm there, and Mr. Brown may be able to come back at the retrial and say, well, I saw somebody else. I didn't know it was Vival, but I knew there was a gun and I knew there was a mob coming at me. And that's why I came out my gun and I shot it. And that the evidence that Mr. Vival would give on retrial that I actually did have a gun, and I don't know why Mr. Brown doesn't remember that, but I showed it to him twice, that may push it over the edge for a jury. I mean, that seems to be what the whole theme of at least the lower court's position is. Well, now there's new evidence that Mr. Brown was getting beat on by Mr. Vival much more aggressively than before. And oh, by the way, Mr. Vival shows a gun, and those facts are now something that wasn't known before. Certainly the gun part.
I think the state is relying on a negative here, what Mr. Brown did not say at his trial. And
For good reason,
ju-
right?
But I don't think that's the same thing as saying, I never saw a gun. He said he didn't see a gun when he was in the ditch being pummeled.
He said he saw a gun from basically a different guy, the guy with the gun on his hip, who I think turns out to be Chris, who's a differently described guy, who Mr. Vival, who you now like his testimony at 3850, said Chris is the bodyguard who always wore the gun on the hip.
Who was
Okay,
part
so
of that pack standing at the rear of the car.
I get all that, but Mr. Brown said at his trial in 2005 that there was the guy with the gun. So it's not new evidence that there was a guy with a gun.
Okay,
And-
counsel, your time is up. Thank you. And we'll now go back to, I think the appellant has 3 minutes and 30 seconds. You are recognized.
Thank you, Your Honor.
Counsel, do
Obviously,
you agree that if everyone testified, yeah, we didn't know Vival had a gun, but now Vival comes back and says, yeah, I had a gun. Nobody knew it, but I had a gun. If that was what we had here, you win, right?
You
Right.
win easier.
right, much, yes, yeah, thank you.
Well, I mean,
Yes.
it's in that point, everyone would agree the gun that Vival had was completely irrelevant to what happened, right? If nobody even knew it was there.
Correct. Right,
But
and
that's,
then,
but that's maybe not what we have, right, counsel? Because the defendant testified, yeah, I saw a gun. Now, maybe he identified the wrong person. I mean, I think probably the point here is, why can't defense counsel at a retrial say, look, yeah, he didn't say before that Vival had a gun, but he did say he saw a security officer with a gun. He just misidentified the one. I mean, he was under pressure. He was being chased by this mob. He was fearing for his life. It was, I don't know, but I assume it was dark, right? Why can't defense counsel just make the case to the jury that, look, sure, he thought he misidentified the person that had the gun. But now we know that there was a gun, that he did see it. He just thought it was a different security guard.
Because the defendant never testified that anyone drew a gun or that that's the reason why he ran to his car. I mean, he was asked multiple times, why did you pull this gun? Why did you feel the need to pull this gun to use self-defense? And it was always that I was afraid of getting beaten up by essentially Marcus Nieto and the mob. That they were going to steal.
But now we know the mob did in fact, as he said at trial, did in fact, at least if you believe, the trial court determined, there was in fact a gun in the mob, right?
Well, I think that there was some evidence that there had been a gun just because of the defendant's own testimony. And then also one of his witnesses testified that he saw something on a hip that was a gun by the time he got to trial. So there was testimony that there was a gun.
Well, there's apparently
already.
two guns. There's apparently two guns now because Mr. Viville said, I have a gun, and I showed it. And then Mr. Viville said, this guy, Chris, the bodyguard, he always had a gun, and he was in there. And that's who actually Mr. Brown talked about, the guy with the gun on his hip. So now there's multiple guns by security guards who are going to be part of the second the retrial that apparently has been granted by the lower court. And doesn't that become a scarier scenario, especially when Mr. Viville and his brother were the main combatants with Mr. Brown?
Except that, of course, now Mr. Viville has 2 felony convictions and he's been sentenced to life.
Apparently
and the fact that
bother somebody, at least.
And that he's got this prior inconsistent statement that he'd be impeached with, and that the defendant never said, I reached for a gun because I was afraid because there was a gun out there in the mob and I was afraid they were going to shoot me.
I mean, the scenario, though, is let's say you had the same evidence at this hearing and Judge Jennifer Harris, not to confuse with John Harris, said, I've listened to that and I don't find any of that what Viville's saying is credible. He's a multi-time felon who's serving double life sentences. He's the most incredible of people and it didn't matter. So it wouldn't matter. And let's say Miss Kaufman was appealing, saying, oh my goodness, look at all these new witnesses I have too. We would probably say, PCA, see you around. You know what? The trial judge saw that, but now it's reversed because she happened to find Viville to be credible, and now you're bought with that, and certainly is helpful to a self-defense claim that the most mad, aggressive guy is now armed and he's showing the gun,
which the defendant never testified to. Which is, you would think it'd be something that he would definitely testify to.
I think the problem, yes, and I understand why you're making the argument you're making, and I'm not, that's all fine and good. But what you're leaving out and what that argument doesn't account for is the fact that, the defendant. Well, let me ask you this: was the defendant ever asked, did you fire into the mob because you were afraid of a gun? Was he ever specifically asked that?
He was asked why he fired into the crowd.
No.
Now, he never asked about a gun.
Counsel, please just answer my question. Was he ever asked, did you fire into the mob in part because someone had a gun?
No, because he had already said that no one else had drawn a gun.
But again, you want to say, you're arguing that his testimony is inconsistent. And I mean, I don't fault you for that. But I'm not, it's not like somebody said, and isn't it true that you fired into this mob because they had a gun? And he said, no. It's just not that clear. You agree? Appellate
was asked if he saw anyone other than himself draw a gun that night, and Appellate referred to the man with the gun on his hand on his hip. Appellate told law enforcement that night that they weren't pulling no guns. He said what he meant was like we was fighting, they wasn't pulling no guns out. And then, however, he admitted that he had not seen another gun drawn before he drew his gun. And then he said he claimed to have been confused when he told the police that night that they were trying to pull him out of the car, that they was coming towards me, trying to get me. And he admitted that he intentionally pulled the trigger, and that he had actually, the reason that he was afraid was because that they would have attacked him, mostly Marcus Nieto, with his fists if he had gotten close enough, and he was not sure if they were going to beat him up or take his money. That's what he testified to. How do you now say, oh, it's all because of this gun that Viville had? It just is not.
You think it has to be entirely because of the gun? You don't think it can be a culmination of the mob plus the mob has guns?
There was already testimony as far as one gun. I disagree. I just don't think if the defendant was mad, it was clear he was just mad. And that's why he was like, basically, I'm going to shoot at these people. If he really was just scared, he would have just shot up, but he didn't. He shot at the crowd and killed somebody.
All right, counsel, thank you for your arguments. And with that, we are adjourned.
Thank you.
Thank you.